The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters. Greetings and welcome to the Personal Safety Show. This is Marcus Melnick from Stress to Logic and Firearm Mentor, where we prepare you to be ready, be sharp, be safe, and train for the moment that matters. Well, last week we had to have a rerun just because we had some other things going on. We had to teach people about safety, but we are back in action, and there's been a lot of news in the last couple weeks. And as my listeners know, I typically don't give updates on so-and-so filed an amicus brief or this person testified, because until there's a result with all of the court cases that many of us are following with rapt attention, there's nothing really to tell to the regular common person. And I am a common person. That's not a ding at all. But as a non-attorney, a lot of it's procedural, the news. So there has been an interesting development this week, and that is a judge knocked down the ATF's engaged in business rule. So this was a significant victory for gun rights advocates, where a federal judge in Alabama has ruled that portions of the BATF 2024 final rule on firearm dealing exceeded the agency's statutory authority. The decision handed down this week could reshape how hobbyists and collectors navigate federal regulations for buying and selling guns, potentially easing fears of unlicensed prosecution for casual transactions. The case, which is called Butler versus Bondi, was decided by U.S. District Judge Corey L. Mays in the Northern District of Alabama's Eastern Division on September 30th, 2025. Plaintiffs, including gun enthusiasts Don Butler and David Glidewell, along with the NRA, challenged the rule's broad interpretation of what it means to be, quote, engaged in business, end quote, of dealing in firearms under the Gun Control Act, or GCA. ATF's final rule, which is effective April 19, 2024, aimed to clarify and expand the definition of unlicensed firearm dealing. According to then-President Joe Biden, the change was over rising concerns over gun trafficking, although many saw reasons as just an excuse. The ATF stated that their reasoning was rooted in the GCA amendments, such as the Firearm Owners Protection Act, or FOPA, of 1986, and John Cornyn's Bipartisan Safer Communities Act of 2022, BSCA. The rules sought to require federal licenses for anyone, quote, engaged in the business, end quote, of selling guns, even if it's not for primary profit. So basically, what the rule originally said was that, if you have so many transactions per year, you're considered a gun dealer. And if you don't have a license, the ATF is going to go after you. So this is a victory for people who are truly collectors. They don't have to get a curio and relic license, although that is not very difficult to do. In other news, the federal government uses an unusual tactic to sue protesters over West Orange synagogue clash. The U.S. Justice Department is suing pro-Palestinian organizations and demonstrators, accusing them of violence and threats during a heated protest outside a West Orange synagogue, using a federal law that has traditionally been used against people blocking access to abortion clinics. The lawsuit, filed September 29th in U.S. District Court for the District of New Jersey, alleges that attendees at the November 13th demonstration outside Congregation or Torah physically assaulted worshipers and used vuvuzelas, I know what those are, plastic trumpets, sometimes used by soccer fans. They're annoying, and it is not a shofar, and that's a joke for the Jewish listeners. And they tried to disrupt the event. The protesters were interfering with the attendees' civil rights to exercise their religion, says the complaint, including gathering for a ceremony to honor the life of a deceased rabbi. According to Attorney General Pamela Bondi, quote, no American should be harassed, targeted, or discriminated against for peacefully practicing their religion, end quote. She goes on to say, today's lawsuit underscores this Department of Justice's commitment to defending Jewish Americans and Americans of all faith from those who would threaten their right to worship. The protest was won in a series of demonstrations challenging local events, promoting the sale of homes and settlements in the occupied West Bank, Israel, considered illegal under international law, according to Yahoo News. Some of the events took place in homes and synagogues, sparking complaints of harassment of Jewish residents outside of houses of worship. Organizers originally planned to protest the real estate sale, where it is to be held at a private residence, but they said they learned about a change in location and went to the synagogue at the last minute instead. American Muslims for Palestine, New Jersey, and 3 individuals named in the lawsuit declined to comment on their allegations. The Party for Socialism and Liberation in New Jersey is also named in the lawsuit, and they did not immediately respond to a request for comment. The politically charged protest in West Orange sparked dueling narratives. Protesters who rallied against the real estate event said they were harassed and assaulted, and a protester from Bergen County required multiple stitches after he was pepper sprayed and bashed in the head with a metal flashlight, according to the Essex County Prosecutor's Office. The office filed charges against 2 pro-Israel counter-protesters, one facing bias intimidation and the other aggravated assault, and the cases are pending. I highly recommend that people take a concealed carry class. Moshe Glick, charged with aggravated assault, said the lawsuit by the Justice Department affirms, quote, the real violations were committed by those who intimidated, blocked, and attacked a member of the community in front of a synagogue. He's filed a motion for dismissal of the case, saying charges against him are, quote, baseless, end quote, and that he was acting in self-defense. Members of Glick's community have rallied to support him, raising nearly $80,000 in an online fundraiser for his defense through the Israel 365 Charity Fund, which raises money for causes that strengthen the people and land of Israel. Its website says, Glick said he had required a public relations firm, political consultants, and video production and multiple attorneys in the effort. He's grateful to Harmeet Dillon, Pam Bondi, and the Department of Justice, who have recognized the travesty of justice that has occurred and the need to safeguard the rights of all people to feel secure in their houses of worship. The real estate event was originally scheduled at Glick's home, but was moved because of threats, says the lawsuit. The event was moved to a synagogue where the suit says a memorial service was also taking place. Protesters arrived at Glick's home for the event and then walked to the synagogue after learning that it has been moved. The lawsuit seeks a court order barring the groups named in the lawsuit from using force or obstruction to interfere with worshipers in any house of worship in New Jersey. The lawsuit comes amid a Trump administration crackdown on U.S. protests over Israel's military actions in Gaza, cutting funding for universities and seeking to deport some pro-Palestinian activists, citing alleged anti-Semitism. It was brought under the Freedom of Access to Clinic Entrances Act, or FACE Act, a 1994 law that prohibits the use of force and physical obstruction to interfere with people at reproductive health centers or houses of worship. It appears to be the first time the law has been used to allege interference with religious worship, says Dillon, the head of the Justice Department's Civil Rights Division. The practice of turning a blind eye to these attacks of the houses of worship throughout the United States stops now, Dillon, who was nominated to the post by President Donald Trump, told reporters at a press conference. Emma Horowitz of the Bergen County Jewish Action Committee said she was grateful to the Justice Department for using the FACE Act to protect worshipers from the harassment, bias, intimidation, and even violence Jews have experienced in recent months at synagogues. Agudath Israel of America, a leading organization for Orthodox Jews in the United States, also welcomed the federal action. Quote, we've seen time and time again how anti-Semitic intimidation has led to violence, said Shlomo Shor, Director of Legislative Affairs for Agudath Israel of America's New Jersey office. No person of faith shall ever feel unsafe or obstructed when entering a house of worship. Some Jewish Americans did not support the Justice Department's action, noting that the protests against real estate fairs have also included Jews who oppose Israel's West Bank occupation and its settlements. Many of the protesters outside the West Orange Synagogue on November 13th were Jewish, as indicated in the witness accounts and photos from the event. Organizers said in previous statements that the protests targeted the real estate fair marketing West Bank settlement properties, not Jewish people. The real estate protests in West Orange and other municipalities in the region come amid an escalation of Israeli settlement activity in the Palestinian territories that critics say are an obstacle to peace. This is very interesting. I know that, because I'm involved, synagogues throughout at least the Chicago area have had additional security, armed people. I've seen photos of synagogues in New York with police standing outside with AR-15s, heavily armed, and just a very interesting time. We're supposed to have freedom of religion. Now, freedom of religion, and the same thing with the Second Amendment, means that the government cannot interfere with the practice. The Second Amendment says that the government cannot restrict firearms practice. The First Amendment says the government cannot restrict protests or freedom of speech. And the reality is this came to a head because of the violence. And other things are also happening in the court system. Judge Reed O'Connor, a chief United States District Judge in the Fifth Circuit, has determined that the ban on possession and carry of arms in common use, so we're talking like concealed carry stuff, in post offices and on property owned by the post office is an infringement on the rights protected by the Second Amendment. And I'm going to read you exactly what the decision says. The decision says, the court determines that both 18 U.S.C. 930, subsection A, and 39 CFR 232.1, subsection 1, are inconsistent with the principles that underpin this nation's regulatory tradition. Thus, they are unconstitutional as applied to carrying firearms inside an ordinary post office or on post office property. The decision was published on September 30th of this year in the United States District Court for the Northern District of Texas, Fort Worth Division. The case is a FPC, or Firearms Policy Coalition, versus Pamela Bondi. The Second Amendment Foundation and two Texas citizens, Gavin Pate and George Mandry, also were parties to the lawsuit against the federal government as represented by Pamela Bondi, the United States Attorney General. The original lawsuit was brought against Merrick Garland when he was the Attorney General on June 18th, 2024. Both the regulatory ban on firearms and other weapons in post offices and the statutory ban on weapons in federal government buildings are relatively recent. The first prohibition on firearms in government buildings occurred in 1964, and the regulatory ban on weapons in post offices was put in place in 1972. Judge O'Connor handed down a summary judgment, which is appropriate when the facts of the case are not disputed. The only dispute in the case is about the law because the plaintiffs did not specify whether the case was a facial challenge or an as-applied challenge, and Judge O'Connor decided to treat it as an as-applied challenge. The remedy only applies to the plaintiffs carrying ordinary firearms in an ordinary post office. So this is not throughout the United States. It doesn't mean that you can carry a firearm into a post office in Chicago, New York, name a location. The judgment is limited to plaintiffs carrying firearms inside of an ordinary post office or the surrounding property, with the exception of post offices inside of restricted areas. For example, a post office in a military base or located in federal buildings, which would otherwise prohibit the carry of firearms. It appears that the plaintiffs will be able to carry firearms in most post offices in the United States. Plaintiffs include all members of the Second Amendment Foundation and Firearms Coalition, as well as the 2 plaintiffs. The judgment applies to both the laws I stated, and it's a post office regulation, and the case only applies to the Fifth Circuit of the United States. The Fifth Circuit includes Texas, Louisiana, and Mississippi. It is unknown if the USA will appeal the Fifth Circuit decision and carry and possession of firearms in post offices. In recent developments, the Department of Justice has refused to appeal a criminal case in Florida challenging the ban on carrying firearms in post offices, and Florida is in the 11th Circuit. The Court of Appeals for the 10th Circuit upheld the ban on firearms in post offices in 2015 in Bondi versus USPS. The case was decided 2-1 in 2015. The Bondi decision happened before the Supreme Court admonished the inferior courts on how they treated Second Amendment jurisprudence with the Bruin decision in 2022. It is likely the Supreme Court will strike down the ban on firearms in post offices when it hears a case on the subject. There is no historical tradition of such a ban when the Bill of Rights was ratified in 1791, or during the period when the 14th Amendment was ratified on July 9, 1868. The Supreme Court has limited resources. A challenge on the ban to firearm in post offices may not reach the federal Supreme Court for several years. We're going to take a quick break, and when we come back, we'll give you more news that has happened in society. I want my listeners to know that this is my dream, teaching people about safety. If it weren't for you, if it weren't for my listeners, I couldn't live my dream. So on behalf of my family and myself, I want to thank each and every one of you for allowing me to live my dream. And I also want to continue to live my dream, and I'm excited to continue to spread the word of safety. Recently, I began a new service as a conference keynote speaker. So if anyone would like for me to speak at future events, or if anyone knows of an introduction or would like to discuss how we can work with one another, I'd love to do just that. The keynote speaking website is www.stress2logic.com. That is STRESS2logic.com. If you're aware of any conference speaking engagements where you'd like to have me speak, I'd love an introduction. You can always share my electronic business card, which is Marcus Melnick, MarcusMelnick.com. Now, back to the show. Hello again, people. Once again, Marcus Melnick here, and there's a couple of upcoming events that I would like to share with you. Next weekend, October 18th and 19th, I have a full concealed carry class. And if you're interested, you can log in. There's definitely space available for you at www.firearmmentor.com/classes. The second day, the 19th, also includes a CCL renewal component. So if you need a renewal, you would sign up for the renewal class on October 19th. If you already have a concealed carry permit and you would love to bring someone else into the shooting fold, I'm a member of the State Line Rifle Association, and they have an NRA Day next Saturday, October 18th. They call it the Family Fun Shoot, and it's held at the Wisconsin Sportsmen's Association, located on 16010 Durand Avenue. That's 16010 Durand Avenue, which is Highway 11, in Union Grove, Wisconsin, 53182. There is a firearm safety briefing with NRA and USCCA certified instructors, and they have ranges for handgun, rifle, trap shooting, and muzzle loaders. The costs are adults are $25, children ages 12 to 17 is $10, and 11 and under will be free with a paid parent. Here's the interesting and good news. All firearms and ammunition will be provided, so you don't have to bring anything. I'd bring some earplugs, I'd bring some eye protection, but you don't have to bring firearms. And it's basically going to teach new people or experienced people. Space is limited, and you can mail in a registration form and payment to guarantee your spot to SLRA, P.O. Box 7837, Gurnee, Illinois 60031-7005. The application will be valid upon confirmation, and your valid email address is necessary to receive confirmation. Registrations received less than 7 days before the event, which this would be, may not be confirmed. Sign-in is at 8:30 a.m. at the clubhouse, and there's a mandatory safety briefing at 9 a.m. Range time will begin approximately at 9:45 a.m., and the event ends at 2:30. The Boy Scouts will be there selling lunch. I'm guessing it's going to be like sandwiches or lunch boxes, that type of thing. The event is funded in part by the NRA Foundation. For more information, I'm going to give you two things. First, an email address, which is camp, C-A-M-P, at statelinерifle.com, and the application is on statelinерifle.com. It's just basically a simple form. You fill it out, you send it in, or you talk to them, and maybe you show up with cash. I'm not exactly sure, but the State Line Rifle Association, we've had them on the show before. It's a fantastic organization, and I would highly recommend that people join. Also, we do a lot of things for the firearms community, and if you'd like to sign up for our newsletter, what that does is it unlocks our recommendations for handguns buying guide. Whether you're interested in a revolver or a semi-automatic pistol, I have a buying guide for you, and to get it, all you have to do is enroll in receiving the newsletter, and you can do that at firearmmentor.com/contact. That's FIREARMMENTOR.com/contact. That unlocks our buying guide for you. And once someone takes a class from us, we do a lot for the firearms industry that really is not a moneymaker. And that's okay, because I am about safety. Sure, I get an income from teaching concealed carry classes, but the value adds are, first of all, I will go shopping with a person who would like to purchase a firearm to ensure that they receive the firearm or select the firearm that is appropriate for them based on hand size, strength, skill, ability, and comfort. Because after a class, we have a relationship. I have seen you in class. I've seen you interact. I know what firearms you've gravitated towards. I know which ones you've gravitated against. And I would love to be able to help you. With that said, please understand, I do not accept any funds from the gun store. No commissions, no back office, no cash gets slipped in my hands for bringing customers in. I get a smile and a handshake. That's my cost. And same thing to the people that are buying. Smile and a handshake is the cost. I am very concerned about getting people the correct firearm that they need for their defensive needs. And they vary. There are people who have poor hand strength. There are people who have physical ailments or disabilities. And there are people that just aren't comfortable with all the mechanics of, say, a semi-automatic weapon. So we take all of that into consideration, and we make recommendations. With that said, it's kind of difficult to buy a gun if it's not in the store. So, of course, it's limited to the selection available. The other value add that I give is after someone takes 2 lessons from me or a concealed carry class, you are entitled to, you will get a free maintenance lesson. And if that maintenance lesson involves firearms that, for example, are not handguns, sure, bring them. Just tell me what you're going to bring ahead of time so that I ensure that I have the right maintenance and cleaning equipment for it. So whether that is a rifle, a shotgun, a non-concealed carry gun, say you have a 1911 that you'll never carry and it's got a bull barrel. There are some limits to this. I do not work on 1911s without a bull barrel. Also, the Smith & Wesson Shield and the Smith & Wesson Equalizer are absolutely fantastic tools. They're great firearms. I highly, highly recommend them. However, I don't have the skill set to work on them. They are a little bit more complex, and the reason why is they are called the EZ line, letter E and then letter Z, and it makes it easier for people. So with those lighter springs, whether it's a magazine spring or a recoil spring, the firearms are very difficult to disassemble and reassemble. So take that into consideration if you are considering that or you have a hand strength issue. The other thing that you can consider if you have a hand strength issue is actually a revolver. There are a couple of revolvers that have really heavy, difficult triggers, and there are a few that have decent triggers, meaning they're reasonable. You can pull the trigger. They're simply, they operate simplistically. And those firearms are made by Henry USA. Yes, the lever action rifle company now has, I believe, 4 different revolvers. 2 of them are in .357, 2 of them are in .22. The only difference is the shape of the handle. The .22 is a 10-shot. The .357 is a 6-shot. I've shot the .357, and it's decent. The trigger is pretty easy. Also, although costly, Colt makes a very, very good trigger, and it's very easy to pull. Alternatively, if you love a different brand, say Smith & Wesson, they have reasonable trigger pulls, but if you need it lighter, you can always get the springs replaced by a gunsmith, and they can do polishing work. And I've got contacts to various people, both gunsmiths and just really artisans who really know what they're doing. So stay tuned. We'll be back in a few minutes with more on firearms and safety. Thank you. The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters.